A subcommittee meeting to order. Today is Tuesday, April 8th, 2025. I would ask that the record reflect the subcommittee members that are present as well as CRMC staff that are here this evening. First matter on our agenda will be approval of the minutes. Those minutes from our previous meeting, that meeting being March 11, 2025, that have been disseminated. Is there a motion to approve them as presented?
Motion to approve.
A motion has been made and seconded. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? The motion carries. Staff report, Mr. Willis.
No staff report tonight, Mr. Chair.
Okay, next matter will be Buttonwoods, Warwick right of way, CRMC file number 2019-03-119, Andrew Comstock Road in Warwick. It is now for status and updates presentation. I would turn it over to Attorney DeSisto at this point.
Okay, the petitioner, Richard Lang, set this here. Could you please come forward? And I understand Mr. DeVideo is representing
Buttonwood Beach Association, the owner of the land.
Could you please come forward? Thank you.
I just want to bring to your attention that I filed a motion for summary judgment. The motion for summary judgment is based upon the fact that the Buttonwood Beach Association went to the General Assembly and sent them a letter, a map. Okay, they sent them a map of the Buttonwoods, and they asked the General Assembly to accept the map in an enactment to make it available to the Buttonwoods Fire District, so the Buttonwoods Fire District could tax the people and make the roads public. Now, when they went to the General Assembly, following case law, which is Knowles v. Knowles, the General Assembly accepted the map and, as a sovereign, presents it as a public highway.
Thank you.
Yes, good afternoon. Christopher DeVideo, I represent Buttonwood Beach Association, EBA, or the respondent, if you will, who owns the land which is the subject of this matter. As I understand, the process in front of the right-of-way subcommittee is that when a petition is presented, counsel for CRMC, legal counsel that is, will present a memorandum of law to guide or assist in your deliberations on any petition. That memorandum of law is forwarded to the petitioner, the respondent, in advance of a meeting. So we have the opportunity to respond to that memorandum of law. That memo and response is then forwarded to council, the subcommittee for consideration in their deliberations. Now, I was recently engaged by the respondent. Last week, I submitted an entry of appearance and requested for the file, the record in this matter. Friday, staff forwarded the records rather voluminous. I haven't had an opportunity to review those documents and digest them to file first. The first is a response to the petition, which I believe will be informative or at least helpful for the memorandum of law that will be prepared by legal counsel and submitted to the subcommittee for review. Moreover, I'm not even sure whether or not a motion for summary judgment is an appropriate vehicle in this type of proceeding. Certainly being filed just over 24 hours, 4/14, I haven't had a chance to respond to that. So I'm going to be requesting an extension of time to digest the material, provide a response to, I believe it's petitions, and we're going to get to that in a second, and then have an opportunity to respond to the memorandum of law in advance of the meeting whenever this is taken up again. Now, I don't think it's going to prejudice or bias the petitioner. And if there is any prejudice to the petitioner, it's certainly outweighed by the prejudice that would occur to my client if we didn't have a fair opportunity to review this material and provide an informative response. And so that's the first request. Second request is to hone the issues. So as I'm reading through the history, I see some things go back to 2017 in some filings up until yesterday. And so I think that we need to hone the issue. What is the petition of petitions? What is the subject matter of those petitions? And therefore, that gives me an opportunity to properly respond. I think that for legal counsel to frame their legal memorandum, understanding and honing the issues as to what is being considered by the subcommittee also informs how much time I need to provide an appropriate response. So based on what I've been able to glean from the material, there seems to be two petitions. One to designate, I believe, and the petitioner can correct me, one to deem Buttonwoods Avenue and Andrew Comstock Road, I believe, and a park at the end of Buttonwoods, all as public rights of way. But that's all I can gain thus far from my brief cursory review of the material submitted.
May I ask a question to the
Yes.
parties? You received the record from the agency.
Ms. Turner forwarded to me Friday afternoon.
Okay. Mr. Langseth, did you get a copy of that?
Yes, I asked for a copy and I got a copy, and I discovered that it has my petition from 2017 in, which was docketed in 2019. And the Buttonwoods Beach Association has had 6 years to respond. They never engaged an attorney until just before the staff report was due out today, as we agreed to 2 months ago. And then all of a sudden an attorney shows up. I'm just wondering why the Buttonwood Beach Association wasn't ready. They've had 6 years. I think it is prejudicing me. It's causing me hardship. And in the record, most of the record is what the Buttonwood Beach Association inserted into the record that I didn't even know about. In other words, for the past 6 years, they never recognized me as a petitioner. They were just slipping stuff into the CRMC record, which prejudices me. And I just thought when I saw that, I said, well, this is the point where we really need to get this organized. Why don't we just go for a motion of summary judgment, which would give them, I don't know if it's 10 days or 20 days. There'd be a period to respond, and then I'd have either a 10 or a 5 day back, and that takes us to the next meeting. So I do believe that they're ready. It's highly focused. We know what happened. We know that they went to the General Assembly. We know that the General Assembly passed with the map. We know from Knowles v. Knowles that by the sovereign is a public highway. I just don't know why they need more than 10 days to look at Knowles v. Knowles and to look at the General Assembly enactment and say, oh, okay, one way or the other argue. I don't think they need to go through 250 pages that they put in. I didn't put that stuff in the record, but what Beach Association put it in. And now they're saying, oh, we need time to review it. Well, they already reviewed it before they put it in. So I just feel uncomfortable with an expansion of time that goes month after month. I don't think we need it. So therefore, and I do believe that you are you're a judicial presence. You're a tribunal. You can accept a motion for summary judgment. I don't see anything in the Superior Court rules of procedure that says I can't put a summary judgment in. And I really think it helps everybody out to do it. I think it makes it so that the staff is not wasting their time going through 250 pages of irrelevant information. And I just think that we can schedule the summary judgment for the next month. And then, if he's uncomfortable with that, that's not my problem, because he's had 6 years to look.
So if I may respond, I personally haven't had 6 years. Maybe my client, who's not an attorney, hasn't had that time, number one. Number two, the most recent petition, as I understand it, was filed on February 14th, 2025. That's not 6 years ago. And I wish it would only be as simple as Knowles v. Knowles. There's a lot of other case law, statutes, which my client didn't insert, nor did the petitioner. If it's been going on from 2017, what's another 45 days or whatever it takes for me to respond, Mr. Hartman and Mr. DeSisto to prepare the appropriate legal memorandum. It's at that point that you'll decide whether or not this petition has merit or not, and then it goes for a public meeting in front of, with the city of Warwick, and respectful. If he's arguing that he wants to go with a motion for summary judgment, I'll answer that very quickly. There are genuine issues of material fact and dispute. I don't think you're going to come to any other conclusion based on what he's asserted and what I'm going to assert. And if there are genuine issues of material fact and dispute, the motion for summary judgment has to be denied. Now, I do know in your rules of civil procedure, your rules of procedure, because there are the regulations and there are procedures. Some of which says that if you're going to submit something for consideration, it has to be submitted 5 days in advance in quadruple. Well, this motion for summary judgment was filed just over 24 hours ago, shouldn't even be considered by this board, even if it's appropriate for it to be considered at this juncture. So again, the prejudice since 2017 for another 45 days, whatever it takes me to provide my response is outweighed. Okay, his whatever he considers an inconvenience is outweighed, but the harm, the lack of due process for my client. I would hope and think the subcommittee would want to have all points of view presented to legal counsel and then to you, so you can make an informed decision. I think it's only fair, good public policy. And again, I don't see how it so harms Mr. Langseth on this matter that's been going on now for so many years. The fact that it hasn't been placed on the agenda, that's not my client's fault since 2017. As I understand it, it's just been recently on the agenda this month for the first time. Seeking a continuance on a matter once is not unreasonable.
Give you the last word.
Okay. Indeed, I presented the petition in 2017, not in 2025. I think we can all agree to that. He's offered to respond to my motion for summary judgment. I think that's entirely appropriate. And if the summary judgment fails, I'm still there to object to all the information that he presents based upon noes v. noes and the fact that they went to the General Assembly. So if the motion for summary judgment fails, I'll be objecting to everything he enters. So I look forward to having him respond to the summary judgment in the next month. I know that I presented it at the last minute. That's because I only discovered the records on Friday. I didn't know what was in the record, 250 pages. I had no idea. So as soon as I saw that, I sent in the motion for summary judgment. We're not hearing it tonight. You know, I didn't present it 5 days before this hearing for it to be heard tonight. I presented it as soon as I could based upon what I found in the record. And my suggestion is that we have it in 30 days. So he has his 5 days notice.
Yeah, I'll take whatever directive you want as to what I need to file, but I can tell you what I am going to file.
Hey, he
I'm
had the
gonna file a
last word.
response. What?
He had the last word.
Well, I understood. I'm going to file, I'm telling you what I intend to file is a response to the petition. And if you direct me, I'll file a response to his motion for summary judgment. I'll do that gladly. And it can be heard whenever it's going to be convenient for the council. Or subcommittee, I should say.
I'm ready.
Okay, thank you. Well, it seems to me that the best thing to do here is to continue the matter so that one, a council can get up to speed on things, and secondly, Mr. Langseth has filed a motion for summary judgment. It did come in a day before this hearing, but he filed it and it should be considered. So my recommendation would be to, in fact, continue this matter, all of the matters pending for the Buttonwoods right of way.
You have a time frame?
It's between 30 and 45 days. That's what I heard. The question is what's the right of way subcommittee availability? And the availability of the parties.
I may have a vacation, a mountain bike race, but I will make myself available at the direction of the subcommittee.
It's my understanding that the subcommittee usually meets on the second meeting rather than the first meeting. So maybe we're going to be doing 42 days or 41 days, but we're really, if the meeting is the second meeting in May, or is it the first?
We are on a rights of way meeting on the second Tuesday, planning and procedures on the fourth Tuesday. However, if the subcommittee wants to flip any of that, it won't be an issue with how you want to handle it.
So it's May 13th or May 27th.
Correct.
Well, I was saying May 27th would give that 45 day-ish. It's around that. So I think it's closer to that. So I mean, it's 2 more weeks. I mean, listening to the arguments, be it 6 years, 7 years, however long it's been. I think 12 more days, 14 more days will afford everyone opportunity to get the best material to us. So my recommendation would be to continue it to the second Tuesday, which would, the second meeting in May, which would be May 27.
For that,
Yeah, we would,
Yes.
please.
I move that we continue Buttonwoods matter to the second Westerly meeting in May, May 27th.
Second.
Motion made in second. Any discussion? Hearing none, all in favor, say aye. Well,
Aye.
actually, you know what? I'm gonna do a roll call. Just to do it. A motion has been made and seconded to continue it to May 27. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
I too, Raymond McCoy, vote aye. So that will be continued to May 27 to afford you an opportunity to give you 14 more days to get the materials together and
Including addressing the summary judgment.
Yes.
motion.
Yes,
yes.
so I need to submit them by when?
Well, the matter's continued to May 27.
Okay,
But what's your,
How about May
Submissions.
20th?
I need 10 days to respond. Or 5 days. I can accept 5. I don't know what your rules are. I don't know if it's 10 and 5 or 20 and 10. I'll do 5 days. So that moves it 5 days, forward from Tony.
May 9th is a Friday.
May 9th is a Friday? Okay. How about May, what's the Monday?
Monday. 12th.
May 12th? May, what's that Friday is,
16th.
May 12th, May 16th.
and submissions of the opposition to the motion of summary judgment by the 12th,
Yes.
and my response to the petitions.
If you could get your response in and including a statement on the summary judgment motion on that day,
Right.
Mr. Langseth, that'll give you a few days to respond.
Great, thank you.
Wonderful.
Okay.
Thank you.
Thank you.
Thank you very much, everybody.
thank you. Next one will be Everett Avenue, Westerly right of way, CRMC file number 2023-03-069. Now for status, update presentation and action on rights of way designation. Turn it over to Attorney DeSisto.
Okay, it was my understanding that there was going to be some opposition to this that has been withdrawn. This is a matter that was addressed by the subcommittee in council many years ago. For some reason, it did not get completed. Based upon the review that we've had, the fact that there is no opposition, I think this is in order to be sent to the council for the final designation. My only question is whether or not the memorandum that would have to accompany it, do you want to see it here at this subcommittee, which has already addressed it and voted on it? Or do you want me to send it directly to the council for their review?
Is there any advantage to us seeing it first? I don't think so, because
No.
it's gonna go to the full council and we would get it as full council members anyways.
Yeah, I think what you decided the last time was that hear from the opposition if there was any. There has not been, and this is something that was already addressed, is already a report. I just wanted to bring an update. I did have an opportunity to speak with the solicitors for the town of Westerly that are here and present tonight. It's my understanding that the town is in favor of this designation.
Yes, we are.
Thank you. And based upon my contact with the solicitors, I thought it'd be appropriate to just update matters and give a travel of the matter, so to speak, for the council.
In your writing,
Correct, yes,
the full council, okay. So do we need a motion here?
correct. The motion would be to recommend to the council that Everett Avenue in Westerly be designated as a public right-of-way to the tidal waters of Rhode Island.
Okay. Do we have that motion?
I make a motion to recommend to the full council that the Everett right-of-way be designated as a public right-of-way to the tidal waters of Rhode Island.
Thank you.
Motion made and seconded. Any discussion? Do we need in the motion your writing to come to the full council?
You can include that, yes.
You wish to include that in your motion?
Yes, I'll amend my motion to include that.
Mr. Gagnon, do you amend your second? All right, any discussion? Hearing none, I'll pull the subcommittee. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
and to Raymond Coyle vote aye.
Mr. Palazzolo had his hand up to speak.
On this?
Yes.
Okay,
As the only person here who submitted any information on this matter, I'd also like to state that I have no objection to approving this right of way as well. Since Bill Connolly didn't submit anything, I think it's important that the record be clear that the information that was provided came from members of the Westerly Harbor Management Commission, which is much maligned in its own hometown of Westerly, and me. Additionally, I would request that this committee next take up Water's Edge Road, because the proof in both the Everett Avenue matter and the Water's Edge Road matter are exactly the same. And the Westerly Town Council referred Water's Edge Road to this subcommittee some 4 years ago now, even though it took Bill Connolly 2 years to send it. Thank you.
done with that one.
Yeah.
No further comment, no, all right. Next on the agenda is Spring Avenue. And Westerly rights of way. It's a CRMC file number 2020-11-084. Status and update and hearing of pending motions.
But that bothers me.
Right.
This is the, your motion to stay, Mr. Forsythe, correct?
That's correct.
Okay. We did receive a response from Ms. Boots for the Attorney General and from the town of Westerly also. And
from Ms. Contrada as well.
yes, and from Ms. Contrada.
May I? Good
Yes.
evening- Good evening, council members.
So,
The district is here to request a subcommittee stay the Spring Avenue extension matter until the Superior Court litigation culminates. The proponents are here to ask the subcommittee to disagree with the Superior Court, the rulings the Superior Court was already made. But as this subcommittee recognized during the last meeting that we held, the Superior Court is going to have the ultimate authority in this matter. Accordingly, it would be in everybody's interest to stay this particular proceeding until the litigation culminates. The district's lawsuit against the town and the Attorney General's office will move forward. That lawsuit has been refiled pursuant to directive by Judge Raspallo in Washington County Superior Court.
The lawsuit will decide that the district owns Spring Avenue Extension outright, and as a result, has the power to exclude others, including the general public, from use of Spring Avenue Extension. Judge Rospallo noted in the motion to dismiss hearing back on January 31st, and this is in his transcript, that over 4 years have passed since this file had been opened, and that he didn't want to see any delays going forward in his Superior Court case. In other words, he plans to call a scheduling conference promptly where the parties will get together and come up with a schedule for when we can ultimately move for summary judgment in that case. The court went as far as to say that, quote, any discovery that's sent out, you're going to want things on a short leash since there's been delays in this. But the CRMC case has been happening a long time. The discovery you can do without that decision getting done, let's get it moving. So that was the court's way of telling the parties that he was not going to tolerate a delay in the Superior Court case. And that's important for you all because this is not a Superior Court case that's itself going to languish for many years. This is a case that judge is focused on and wants to see move forward expeditiously. Let's talk for a minute about where we stand in this particular proceeding. We're not at a hearing yet. Significant discovery disputes remain, despite that a lot of work and discovery has been done over the last year. Significant disputes remain. In particular, the Attorney General's office has withheld hundreds, if not over 1,000 documents from us, wrongfully claiming that they are covered by a common interest privilege. We've been waiting for a couple months to hear back from the Rhode Island Attorney General's office on this issue. We heard back from them today, and their response to us was to actually want to withhold more documents than they were previously withholding. We need to review their response and engage with them further in order to see what their grounds are. And we're ultimately going to need a motion to compel. If this proceeding moves forward, we're going to have to file a motion to compel production of those documents from the Attorney General's office for this subcommittee to decide. Significant discovery disputes remain with Save the Bay. It's our position that Save the Bay did not appear at its deposition prepared to testify fully, and also that Save the Bay has not provided the documents that this subcommittee asked for in the subpoena that was sent to Save the Bay. We hope to resolve these issues with Save the Bay amicably, but it's unclear how long it's going to take for us to resolve those issues. But let's not make this particular process more than it is. The CRMC is charged with identifying existing rights of way. There is zero evidence in this record as it exists today that Spring Avenue Extension was ever an existing right of way. Over 20 fact witnesses have been deposed in this matter. Not a single one can support the notion that Spring Avenue Extension was used as an existing right of way. One witness for the proponents walked on the unfenced side of the Spring Avenue Extension while he was working as a guard in the 1980s. Another one thought she saw a fisherman walking on it, but couldn't verify that when pressed under oath. Most of the proponents' witnesses can't even identify on a map or a photograph where the Spring Avenue Extension is located. Others who initially claimed in their disclosures to know where the Spring Avenue Extension was or to have used it, when pressed under oath, admitted that they thought the boardwalk path that the Weekapaug Fire District maintains was the Spring Avenue right-of-way, and it's on a completely different parcel. Most witnesses, when shown aerial photographs from the 1950s, 60s, and 70s, were forced to admit that they did not see any evidence of a path over the Spring Avenue Extension parcel in those photographs, because there was none. The proponents instead plan to ask this subcommittee to find a right-of-way exists based on a couple of zoning maps. A couple of zoning map stampings from 1939 on a plat map that had nothing to do with the Spring Avenue Extension and everything to do with a piece of Spring Avenue that was meant to serve the relocated Weekapaug Inn following the 1939 hurricane. Even the proponent's own expert, Joseph Priestley, admitted the town never marked or graded Spring Avenue Extension or took other steps to accept it. even if those stampings were to serve as some evidence of a dedication. It's not even clear to us that CRMC has the ability to find that a statutory dedication occurred. This is all a lengthy, expensive, and wasteful fishing expedition based on wishful thinking and the theories of the proponents. For all these reasons, the district's lawsuit carries more weight. We have taken on the burden of going before the Superior Court, taken on the burden of proof to show that we own Spring Avenue Extension outright and can exclude any party from Spring Avenue Extension. The proponents will stand up here in a minute and tell you that they've moved to dismiss the case yet again. What they won't tell you is that those motions to dismiss really don't have a shot. They were the same motions they filed that the Judge Respallo denied in the previous case. We've already sent letters to Judge Respallo asking for a scheduling conference whereby the next steps in these cases can be determined. In fact, the very order that the proponents signed on to resolve the initial litigation that was filed in Providence County confirms that. It says the motions to dismiss were denied on substantive grounds based on 12B6 and 12B7. They submitted that in their own order. To reiterate here, we don't see there as being a gray area. Spring Avenue Extension has been fenced off for decades and impassable for close to a century. That's what the evidence says. The evidence is that it was never used. There's certainly no evidence of use by the public, despite all the depositions that have occurred. A couple stampings on the 1939 plat map do not constitute dedication. Even if it was dedicated, the town never took steps to accept it. I now have to cover 4 elements that govern whether a stay is appropriate. The first is whether the district is likely to succeed in the merits of litigation. Well, the district's already satisfied that prong by getting past the motion to dismiss phase before Judge Respallo. If the lawsuit wasn't meritorious, he would have granted the proponents, the town, and the AG's motion to dismiss that case. Courts routinely resolve land ownership disputes based on relevant evidence, such as the chain of title and the land evidence records. That evidence is all squarely in favor of the district here. Contrary to the proponent's wishes, the district is not required to exhaust its administrative remedies. Judge Respallo has already held so. The district is not asking the Superior Court to determine whether Spring Avenue Extension should be dedicated as a right-of-way. We don't dispute that that's the purview of this subcommittee and not the court. The district is asking the court to do only what the court could do, and that is help us quiet title to this parcel. Again, we're taking on the burden of proof in the court action. The court's ruling will inevitably be dispositive on what's before the subcommittee here. Therefore, we see no reason in continuing with a parallel proceeding before the subcommittee when the Superior Court will be dispositive. The second element is that the district will suffer irreparable harm. The district, and frankly, everybody in this room would suffer irreparable harm from putting forth 2 parallel proceedings where money's being spent and time's being spent to adjudicate this matter when the Superior Court, again, is going to be dispositive. Taxpayers are putting the litigation expenses of all of this. The district taxpayers are paying for both the district's purview as well as for the expenses the town is incurring. So we think there's a lot of efficiency in limiting this to a single proceeding that's now gotten past the motion to dismiss phase in Superior Court. The proponents will not suffer any harm, let alone substantial harm. Substantial harm is the test. This case is going to end up in court regardless, so we're all better off having the Superior Court proceeding move forward now. The hearing on the merits here hasn't started, and we're not frankly close to that for the reasons I've already stated. We've got discovery disputes that remain and evidentiary issues to resolve. Finally, the fourth element is whether a stay would harm the public interest. This element is not whether the stay is in the public interest. It's whether a stay would harm the public interest. Nothing will change by staying this matter presently before CRMC. Access to the in-beach is currently afforded by way of the Weekapaug Fire District's boardwalk at all hours, except for currently the beach hours in the summertime. That's not going to change. That's the status quo. And that's by purview of the fire district. It thus leaves, this is going to be left in CRMC's hands, your hands, to make an efficiency-based decision on whether it makes sense to have a parallel court proceeding going with this proceeding, or whether it's best left for the court proceeding to go forward while this sits idle in order for the court to sort out these issues. For all these reasons, the subcommittee should stay Spring Avenue extension matter pending the outcome of the Superior Court litigation. I appreciate you listening to my monologue.
Thank you.
May I sit while I present? I have some notes that I want to reference, and my eyesight isn't what it used to be, despite how close I am to the table.
Yes,
So may I sit and present?
yes,
Thank you.
you're welcome.
William Conley, on behalf of the town of Westerly. This motion has a kind of innocuous sound to it, a motion for stay. As though we're just asking this committee and the council to take a break from this proceeding while we go up and do things in Superior Court, which I'll address in a moment. But this is an incredibly significant issue for the Coastal Resources Management Council, for the Rights of Way Subcommittee, and most importantly, for the people of the state of Rhode Island and the good citizens of the town of Westerly. Because what this motion really is about is the question of whether or not this Rights of Way Subcommittee and the Coastal Resources Management Council has jurisdiction to determine rights of way to the tidal waters in the state of Rhode Island. Because what you are really being asked to do today, and if you choose to do it, you will do it forever, is to relinquish your jurisdiction over the determination of rights of way to the coastal waterways in the state of Rhode Island. You haven't heard anything at all in the argument which asked you to state this matter about your jurisdiction. You are nevertheless being asked to eviscerate Title 42, Subchapter 23, Subchapter 6 of the Rhode Island General Law. The Rhode Island legislature, in its wisdom long ago, determined that there was a need to establish jurisdiction and a process to guarantee people in the state of Rhode Island access to coastal waterways. As a consequence, when it created the Coastal Resources Management Council, it vested that Coastal Resources Management Council with that jurisdiction. One of the council's primary explicit responsibilities is to designate public rights of way to tidal waters. And again, it's in that section of the statute, 4623(6). You're being asked today to give it up. If you give it up in this case, you will have forfeited it forever. you will have forfeited a legacy, a tradition, a legally invested responsibility in the council that's been exercised about 337 times over about 216 sites in the state of Rhode Island. That's what that legislation accomplished. You have the expertise. You are uniquely suited to make this determination. Now, the town of Westerly has great respect for Judge Spallo and has great respect for the Superior Court. I'm not going to gainsay what's in the mind of Judge Spallo in the litigation. It's not for you. It's not for the district to represent you. It's not for me. Try to read his mind and tell you what's in it. But whatever is there, whatever Judge Spallo does with the cases in front of him, cannot interfere with your jurisdiction and your responsibility to make this determination. Now, after a lot of talk about the Superior Court cases that aren't even, but by the way, which were improperly filed and thrown out, which required the filing of new causes of action, which I'll suggest to you that despite representations to you this afternoon, that they are the same cases, they are not. That's a side and collateral issue, however. The fact that those cases have causes of action in them that have nothing to do with the determination of rights of way, the fact that the new cases filed finally in the right county give up claims that were in the prior cases, don't include parties to it. And by the way, you know, as you know, the town of Westerly and the state aren't the only people in front of you. Town like Contractor is in front of you as well. And even though the district is asking the court, the Superior Court, to make the determination about the right of way, it doesn't even include the intervener in that lawsuit. Doesn't even name her as a party. How do you do that? How do you go before a court and say, hey, you know that proceeding that's going on in front of the Coastal Resources Management Council Right to Way Subcommittee? We're only going to bring some of the people that are in that case into this case, Judge. How do you do that? It's some kind of different case with causes of action that have nothing to do. They have slander of title in it, ask for damages. So that's all collateral. Because the real issue is, should you give up your jurisdiction? And I suggest to you that the Rhode Island general laws do not allow you to do that. Now, you heard a lot of purported and represented facts in the presentation just made to you, both as a preface and as a part of the argument addressing the standards for a stay. So let's talk about that a little bit. Well, I may not agree about much. We do agree what the standards are for a stay. So, the first prong, that the district will prevail on the merits of its appeal. Well, it suggests to you that you shouldn't do that examination. I want to take that away from you. Because it says Judge Spallo already did that for you, let's move on. Well, Judge Spallo, with all due respect to the jurisdiction of the Superior Court, is not here today. This is your determination. And in support of that first prong, you heard a lot of representations about facts. Some facts that allegedly have been sort of determined and acquired through the discovery process that you've all heard a lot about, not facts. These are the facts, you have them on the record. Beginning of this proceeding, this body directed the parties to submit stipulated facts. As we appear before you this afternoon, these are the only facts in the record, but you didn't hear anything about these facts. Back in June of 24, we stipulated 27 facts to you. Those are the only facts in this record. These are the only facts that you can take administrative notice of. Everything else is mere representations. You didn't hear anything about these facts, not one of them. But because those representations were made, I feel obligated to at least address them for you. Because there is no likelihood of success on the merits here. Why is this motion to stop you from conducting your hearing and to stop the council from conducting its hearing being brought now? You're well aware, through the extensive motion practice that has taken place in front of you, of the efforts, the time, and the resources that have been dedicated to this proceeding already. Why wait till now? Well, there's been about, let me get the number right, I don't want to. It's been about 31 depositions taken in this case. There's been well over 100 documents exchanged between the parties. Been something like 53 interrogatories, substantial requests for reduction. Why is it, once that discovery process has taken place, that now there's a decision made by the FI just say, oh, don't look at that evidence? We don't want this rights of way subcommittee or the full council to hear that evidence after we've done all that work. Well, a logical inference is that they don't want you to see that evidence because they don't like what it shows. Don't want to go too far afield on that, but again, I think there's a need to respond. Soon represented to you that there's always been a right of way, and it's never granted to the town. There's never been a public right of way there, and all this evidence, all this discovery. But what you already know, because of the work that you've all done in the area of rights of ways, that there are two means by which a public right of way can be established. One is through common law recipient dedication, and another is through statutory dedication. You're not going to be surprised to hear that the town, the state, the intervener all believe and are convinced and want the opportunity to present evidence to you that both of those are satisfied in this instance. Because when you give us the opportunity to present that evidence to you when you recognize this request for you to surrender your jurisdiction for what it is. You'll see evidence that the town of Johnston endorsed in April of 1939 revision to a plat which clearly support a finding of statutory dedication. You'll see the process that existed in 1939, that the plat had to be submitted to the zoning board at that time, that the highway commission had to approve it, and that the plat had to be recorded with the town clerk. And the town clerk was sort of the last keeper of the gate to make sure that all of the boxes had been checked before it was recorded. You're going to see public documents that show that that is an undisputed fact. The documents will speak for themselves. That 1939 revision plat was submitted to the zoning board, approved by the zoning board, went to the highway commission, and was recorded in the public records. Now, there's more in support of that, but this isn't about proving that now. In 1920, plat, which wasn't recorded until 21, it's a map of the Weekapaug Beach belonging to the Weekapaug Beach and Land Company, establishes an incipient dedication. Again, without going into all of the documents and record in support of that, which you will see when you properly exercise your jurisdiction and act as the finders of fact in this case, that 1920 plat was accepted by the public. (1886) plat, recorded in 1915, puts a map of the Weekapaug Beach belonging to John A. Taylor, further supports the incipient dedication. A circa 1911 plat, and recorded between 1911 and 1913 of the property of the Weekapaug Beach and Land Improvement Company, located at Weekapaug Point, further supports the incipient dedication. So we're not cherry picking. We're not going to pick isolated points in history. We're going to build a chronology for you. We just want the opportunity to do it. Now, what that representation of the new lawsuits filed, what wasn't highlighted for you is one of the declaratory judgment requests. As I said a moment ago, there's things about quiet and title, there's abuse of process claims against the town of Westerly, there's those slander of title claims, but the declaratory judgment request. And that declaratory judgment request says that the town and the Rhode Attorney General should be barred from questioning the WFD's ownership, but should be barred from asserting a public right-of-way through the CRMC process. In other words, the town of Westerly and its citizenry should not have access to the Coastal Resources Management Council for rights-of-way designation. The town of Westerly and its citizens shouldn't have the same access that those other 337 applicants had. We should be denied that access. What is the likelihood of this body, because this is in front of you, of denying the town of Westerly, its citizens, through our Attorney General's office and Caroline Contrada, access to your jurisdiction. Very little. Will it suffer irreparable harm? Well, look at the memo that was filed with you. Find anything that sounds like irreparable harm, and listen to the presentation that was made a few moments ago, and try to see something in there that was irreparable harm. There's something about, well, there's two parallel proceedings. It's not very efficient. Irreparable harm is a real imminent injury for which there is no adequate remedy at law. There is nothing in the papers and nothing in the presentation to you that suggests there's a real imminent injury. And by the way, financial and economic matters can never be irreparable harm. So the idea, unfortunately, that the Weaker Park Fire District citizenry is paying a lot in lawyers' fees is not irreparable harm. No substantial harm will come to the interested parties. Suggest to you that if you deny the town of Westerly and its citizens access to your historic jurisdiction, well recognized in the legislation, and by the way, we cite to the Sartre case in our papers. I don't need to go through it again. You all know that case. If you deny that access that the Rhode Island Supreme Court says we have, we are irreparably harmed. The other irreparable harm is this. And it kind of segues into the prong about public interest. Because along with that investiture of that primary jurisdiction in you, the legislature also directed the council to establish its proceedings. How are you going to accomplish this task? Establish the process, and you did. And as a part of that process, a point in time will come when we get to hearing where the members of the public will be heard. Why is that critical as a part of the process and fact finding for rights of ways? Because your task is to find those historic rights of ways, where they already existed, regardless of what property rights are, regardless of what the fact is. Your rules, regulations, and the statute outlines all the factors that you look at. You should have the opportunity to do it. But it's telling you today, don't do that. And by the way, that cuts out the citizenry of the state of Rhode Island. The public can't participate. We're going to cut them out of the process. It's not what the legislature wanted. That's what the council wants. Now, they may not like what the public has to say. God knows I don't always like it. You just heard a few things, I don't necessarily always like the thing the public has to say, but they have a right to say it. Whether I like it when they say it about me, whether the fire district likes it when they say it about this right of way, the public should be heard. So not only are you being asked today to surrender your jurisdiction, once and for all, by the way, once you do it here, as I said before, you can't reclaim it. You're also being asked, cut the public out of the process. Those other 337 times that the public participated was a mistake. Don't give up your jurisdiction. Get to the truth. That's what you're here for. Determine whether or not the Spring Avenue extension is the right of way. You've given us lots of opportunity to do it. You've given us lots of opportunity to do discovery. Hear the evidence. Don't cut out the public. And protect the process that has provided about 216 rights of ways to the coastal tidal waters in the state of Rhode Island. Deny, see this for what it's worth, this motion for what it really is, and deny it. Thank you.
Thank you.
And Boots for the Attorney General's Office, State of Rhode Island. I just have a few things that I want to address. First and foremost, and I don't mean to beat a dead horse, but Justice Respallo has never said that these proceedings before the subcommittee should not go forward. He has never said that these proceedings should cease. He has never said that they should yield. As discussed by the town, this jurisdiction does belong with you. And once you set the precedent that you are giving that up, that's very hard, if not impossible, to reclaim. You're not disagreeing with the Superior Court by keeping this matter here. And as the town pointed out, many of the counts in the complaint that has been filed in the Superior Court are completely irrelevant to this proceeding. I do feel the need to point out, just because the fire district discussed our privilege log a little bit. The fire district had that privilege log for about 7 months before returning it to us with some incredibly broad issues. We addressed those issues in detail in less than 2 months, and we got that back to them as quickly as possible. We would like this proceeding to move forward. We would like this to go to hearing. We would like the public to have their day before you. There are probably some disputes in that regarding, for example, common interest privilege amongst the proponents. And some of that will be addressed through the APRA decision. Another case that the fire district brought related to Spring Avenue, and that decision has not come out yet. But I do just want to point out that our timeline, we've been very diligent at getting back to the fire district. But that's not what this motion to stay is about. As the town pointed out, this motion to stay is about your jurisdiction. The Supreme Court of this state has reiterated that the legislature gave you jurisdiction over rights of way. The Superior Court has not disagreed with that. They have not said, Judge Respallo has not said that you should cease or yield these proceedings to him or anyone. For those reasons, and the reasons discussed by the town, the state does ask that you deny the motion to stay. Thank you.
Thank you.
Sean Linus, filling the unfillable shoes of Michael Rubin on behalf of Ms. Contrada. I'm not liable to improve on what my brother and my sister said here, so I'll be very brief and just remind the council of what I think, or the subcommittee of what I think it already knows, which is that judicial proceedings are just different forums than administrative ones. Namely, in that they don't allow for public participation. And it certainly is true, as the town has intimated, that Ms. Contrada is not named in the judicial proceeding. We're not asking to be named as a defendant in that proceeding. We shouldn't like to subject Ms. Contrada to liability. But if this case were to proceed solely in a judicial forum, she would be precluded from participating. And as would all the other members of the public, many of whom actually, quite frankly, have been more diligent about attending these proceedings than even I have. The reason the General Assembly gave you this authority, in part, is so that the public can participate, exercise their jurisdiction. It's important that the public be a part of this process. Thank you.
Thanks.
Brief rebuttal.
Thank you. A lot of bluster about this being a jurisdictional issue. All we're asking for is a stay. We're not looking for you to relinquish anything. Put the matter on pause while the Superior Court looks at our proof, our affirmative proof, and assesses whether that proof is enough that we should be subjected not only to this process, but to all of the discovery issues that we've been subjected to over the last couple of years. To the cloud on our title, to the fact that there's going to be an appeal by some party after this proceeding ends, this fact-finding proceeding ends. I have to address the fact that, yes, Ms. Contrada was left out of our lawsuit because she begged out of the first lawsuit, and Judge Raspallo found that we did not have to include her. So it was our choice this time around to not include her. She did not want to be involved in the lawsuit. A stay, which again is what we're asking for here, not some foreign concept. The Rhode Island Supreme Court has laid out the elements, which we went through already today. And the seminal case on that is Narragansett Electric Company versus Harsh, 367 A2D 195 to 1976 case that lays out the elements of when a stay of an administrative proceeding is appropriate. So we're not asking something here that's never been heard of before. Council spoke of an opportunity to build a chronology for us. Again, we've been before this council for 4 years. We'd love to see the chronology. All we ask is that we be granted a reprieve from this particular proceeding while we put on our evidence in the Superior Court before Judge Raspallo. He has a chance to look at our affirmative proof, determine if that proof is enough, as we think it is, to get us out of this process and end the Spring Avenue extension dispute for good. In the end, it's worth the investment of time for this subcommittee to give us the period of time necessary to get the summary judgment in that case, which might be 8 or 10 months' time, and get a ruling there to inform whether we need to go through this humongous process here. Let me pause and ask if you all have any questions for me before I sit back down.
Any questions from the subcommittee? Questions? No questions.
Thank you very much for hearing me this evening.
Thank you. What else, Tony?
That's it.
I just say one last thing. I do just want to point out that the Superior Court is not the fact finder here. You guys are the subcommittee, is the fact finder. The subcommittee is the group of experts. You are the ones that are supposed to be fact finding here. The Superior Court is to give you deference in your fact finding. Thank you.
If I may, Superior Court is a separate proceeding, separate burdens of proof, and we will supply the evidence we need to supply the Superior Court, and it will make rulings in that case.
Thank you. What next, Anthony?
Thank you all. So, basically the arguments that have been presented here are legal as opposed to factual. And the question is whether or not there should be a stay of these proceedings while the Superior Court case is going forward. But under 4623(6) subsection 5, a jurisdiction for the determination of these public rights of way to the tidal waters of Rhode Island is granted to the agency. That's the first thing. The second thing is the administrative remedies haven't been exhausted yet for this. I understand that the case was filed by the Weekapaug Fire District. But this came first in time. There's been a lot of work that has been done here. A lot of the factual findings, as the lawyers have said, have taken place at this level. The subpoenas that, by the way, that you guys have issued. You know, to me, the issues here are whether or not the administrative remedies have been exhausted yet. They have not, because this proceeding hasn't wrapped up. As a Superior Court to date, it's the same judge, but no stay has been issued at that level for these proceedings. And you do have original jurisdiction for matters of this nature. You're not determining the underlying ownership of the Spring Avenue extension. What 4623-65 has you do is make a determination as to whether or not it's a public right of way to the title waters of the state. And I think that's why it's proceeding over here, absent any action by the Superior Court. My recommendation be here to deny this motion to stay and have this matter proceed forward, where there's already been all this activity to date. That's my advice to you.
All right. Any questions of our counsel? Subcommittee to our legal counsel? No. You've heard the recommendation from our legal counsel. Is there a motion?
I think I would kind of agree that we should continue our process. We've got so much invested and there's still more to do, so I would make the motion to deny the
Motion to stay.
The motion has been made to deny the motion to stay.
Also, I agree with that and I'll second it.
Second by Ms. Reynolds. Any discussion? Hearing none. Hold the subcommittee. Mr. Gagnon,
Aye.
Ms. Reynolds.
Aye.
I too, Ray McCoy, vote aye on the motion. The motion to stay is denied. What does it bring us?
On this matter?
Yeah. For this evening.
We can proceed. I think what you need to do now is just follow what's on the agenda. This was the only thing on these motions. So I think your next motion is to adjourn.
All right.
So moved.
Motion made and seconded. Any discussion? Hearing none, all in favor, say aye.
Aye.
The subcommittee stands adjourned. Thank
Thank
you
you all.
very much.